without further ado, then, we'll get into the substance of today's session. So for today's online expert briefing on international humanitarian law, we're looking at the subject of IHL regulating humanitarian activities, and in particular looking at key findings from the updated ICRC Commentary on the First Geneva Convention. We're very pleased to have with us from the ICRC Bruno Demeyere, who's a legal advisor with the ICRC, has been since 2011, also happens to be a founding member of PHAP and has lectured extensively around the world with PHAP and others to audiences of both military personnel and humanitarian practitioners, and has been, of course, working on this project of the updated commentary. And we're very pleased to have him here with us to give us an in-depth look at the findings that have recently been published. We're going to be starting with Bruno with a brief overview of the commentaries project generally, after which Bruno will present the main substantive findings of the research, specifically on Common Articles 3, subparagraph 2, and Common Article 9 of the Geneva Conventions, and importantly, what this means for humanitarian practitioners. And as I mentioned, following this, there will be an opportunity for questions and discussions at the end. So now, Bruno, I'll hand the floor over to you, and it looks like we have the presentation coming up here. So over to you, Bruno.
Thank you, and Harriet. Good afternoon, everybody. Good morning, good evening, because I see these people from various time zones around the world joining us this afternoon. My presentation will be divided in two parts. I'll first take a couple of minutes to give a brief overview of the ICRC Commentaries Update project in general, just so you have a sense of why it was initiated, what exactly it is about, what is a commentary, how was the process led, what type of steps were taken prior to the publication of the First Geneva Convention commentary a couple of months ago, and then basically use that as a stepping stone to illustrate the approach of the ICRC commentary through one particular example, which I know is of day-to-day relevance to many of you in your work, which is the provisions in the Geneva Conventions dealing with humanitarian activities, and more particularly the right for impartial humanitarian organizations to offer services to a party to the conflict. Now, first, trying to get this, change the slide. So, if we say that commentaries had to be updated, it means that there was already an initial commentary. As some of you may know, so the Geneva Conventions date from 1949, and the ICRC, and at the time it really was an internal ICRC effort, in the years that followed the adoption of the 1949 Geneva Convention, published its own article-by-article commentaries throughout the 1950s. And did the same when it comes to the additional protocols, so which date from 1977. The ICRC published its commentary in 1986. Now, what's a commentary? Because that maybe develop some mention before we go into the substance. A commentary is a commentary. This may sound very banal, but it means that the commentary is not there to amend or replace the treaty. The only legally binding text which states have signed upon and ratified, and then have to implement it in their domestic legal order, is the treaty. That's the legally binding text. Commentary is not, and is never going to be, legally speaking, binding. What a commentary does, however, intend to do is to provide you with background information as to why a given treaty provision was adopted in the first place. What was the subject the states thought deserved regulation? What were the various proposals on the table during the diplomatic conference? Were there any competing proposals, and how were they reconciled in terms of final drafting? And this is pretty much what the initial ICRC commentaries do. It's the experience of the ICRC delegates who participated in the diplomatic conference in 1949. For every single article, they explain what was the issue, what was the negotiation, and why was the wording chosen as it was. And also quite frequently especially for conventions 1, 2, and 3. The commentary will explain how the 1949 text is different from the previous conventions, such as the 1929 Convention on the Protection of Wounded and Sick. And that's also where most of the times the commentary stops, because they could not yet know, the drafters of the ICRC commentaries in the 1950s obviously could not yet know what would happen afterwards in terms of battleground practice, implementation, or difficulties in terms of implementation, or also where a given wording that seemed clear at first sight turns out to be very difficult to interpret in practice. So the ICRC therefore decided 5 years ago in 2011 that it was time, and it was time, some 6 decades after the initial commentary, to update its commentary. And it did so also like the initial, keeping the initial format, which is to provide an article by article, and I'll show you in a minute, paragraph by paragraph, and for some conventions even word by word, commentary on what does this mean, where are the fault lines in terms of the debate, and also give a sense, I'll come back to that point later on, to the extent there are diverging views between states or between an ICRC view and a competing view held by some states. The purpose of the exercise is to give the reader a fair and comprehensive overview of the full panoply of interpretations that exist on any given provision. So the idea is to reflect both the ICRC view and any other views that may exist. Now, if I say reader, who do we have in mind? It's basically everybody who is dealing with the application, the implementation, as well as the studying, the monitoring of international humanitarian law. So I would say first and foremost, we're thinking about legal advisors to armed forces, legal advisors within ministries, judges, prosecutors, domestic courts, international courts, as well as students of and academics of international humanitarian law, think tanks, and last but not least, humanitarian practitioners who sometimes will find themselves in a dialogue with parties to an armed conflict as to the interpretation of a given provision. So I'm here obviously thinking of my own ICRC colleagues who will be using the ICRC commentary, as well as other impartial humanitarian organizations that in order to make an argument, a protection argument, will hopefully find it useful to look at the commentary to gain further information about a given provision. So the planning for the next few years is that we just published in March of this year the commentary on the First Convention, which is protection of wounded and sick members of the armed forces in land warfare. That one is online, and I'll show you in a second where to find it. Next year will be the publication of the commentary on the Second Geneva Convention, which is protection of wounded, sick, and shipwrecked members of the armed forces for naval warfare, sea conditions. And then in 2 years from now, though we're already working on it with the project team here in Geneva, we are going to publish the updated commentary on the Third Convention, which is dealing with the protection of prisoners of war, to be followed in 2019 with the Fourth Convention, which is protection of civilians, including the provisions also on occupation are found in the Fourth Convention. And then in 2020, 2021 is last but not least, obviously, the additional protocol commentary. Now, where to find on our website, if you go on the ICRC website, the way to find the commentary is to click on the section entitled War and Law, and then there's a chapter heading saying Geneva Conventions and Commentaries. And this will bring you to the following page, which is the overview of the entire First Geneva Convention, article by article, where you'll see, so the right-hand corner, you'll see for every single provision, there's commentary of 2016. And so if you click on there per article, you'll get access to the online version of the updated commentary. As you will see, the initial commentary from the 1950s has been maintained online. So it's not as if the ICRC has now withdrawn the initial commentary. It's still there and remains its validity in a historical context. I should also mention that, so this is the online version. By the fall of this year, Cambridge University Press will publish the entire commentary in physical book format, for those of you who prefer books as compared to watching a screen. Now, to give just one example of what a commentary looks like, I took the commentary on one of the key provisions specific to the First Convention, Article 12, which is protection and care of the wounded and sick. And there the format, and this is a format you will see used for every single commentary, is first there is an introduction, which basically summarizes what this is about, and also situates the provision in the context of other similar provisions in other treaties or in the context of customary law. Subsequently, you will always find a historical background, which explains where the provision comes from, whether it's already been had already been captured in previous treaties. And then comes a very detailed substantive analysis, as I said, like sometimes not only paragraph by paragraph, but also word for word, to really go into a detailed legal analysis of the meaning and the various opinions that exist with regard to the interpretation of a provision. So this commentary is a commentary in the classic sense of the term. It's not a law review article where you try to combine various articles, various themes to make a compelling case on a given point. We also don't expect people to actually read from A to Z, the 1,000 pages that are the commentary on the First Geneva Convention. Rather, the expectation is that practitioners, including a lot of you, I think, in your daily work, will gradually start using it and then hopefully find it useful in order to incorporate elements of the analysis in an argument, a legal argument you're seeking to construct. So the purpose to summarize a little bit what has been said so far, the purpose of the exercise is to make sure that we continue to be able to demonstrate that the Geneva Conventions are relevant. And in order to make that case, it was felt that all practitioners of IHL need up-to-date, clearly accessible and easily accessible interpretation available in order to quickly find out the meaning and interpretations that exist with regard to given provision. Now, one question that often comes up, and I won't bore you because you'll find all the details on the website in terms of the various steps that have been taken in order to get to the publication of this commentary. Suffice it to say that a lot of people were involved in reading various drafts at various stages, both, and this is interesting and innovative as compared to the initial commentaries from the 1950s. People were involved both inside the ICRC as well as outside the ICRC. So some of the provisions, some of the commentaries have been drafted by outside contributors, and they were also involved in reviewing the drafts prior to publication. There was one final step that was taken in 2014 prior to publication, is that the entire manuscript was circulated to a worldwide, and this term is not underselling the point, it was really a worldwide process of peer review where very eminent scholars, judges, military practitioners were given the opportunity to comment on whatever they thought they felt they had to comment on, to point out things they felt were wrong or deserved to be better argued, etc. And those points were as much as possible taken on board in the final version. So what you see is not just, there's a small project team in Geneva managing this on a daily basis, but the credit really goes to the innumerable people from around the world who have been involved in making sure that this was the best possible snapshot of that could be given anno 2016. As I said before, you will find, to the extent it exists, an overview both of ICRC interpretation and then the diverging views. Also, obviously, when we speak about updating a commentary, you will find many topics in the commentary that the initial drafters in the 1950s could not even have conceived about. One easy example, but I could give others, is when looking at the definition of international armed conflict, so Common Article 2, there is a discussion in the updated commentary on how this debate plays out in the context of cyber warfare. Same with Common Article 3. Can a non-international armed conflict be triggered by virtue of cyber hostilities? Obviously, in 1950, this did not exist. These, among many, many other topics in terms of new technologies or new developments, are aspects which you will find reflected in the new commentary. Sorry. One final point. So the commentary wants to be both easily accessible, hopefully become authoritative, but also be held to the highest standards of academic integrity in terms of sourcing and referencing, and to provide what we hope will be for every single article a useful bibliography. And those who will be looking at the bibliography will notice on some articles entire libraries have been written, say Common Article 1 or 2. Other articles have attracted much less interest in the 6 decades since the 49 Convention were adopted. And you'll see that on some, there really is only a handful of publications that extensively dealt with the analysis of a given provision. As military manuals also sometimes only merely paraphrase either the Convention or the initial commentary, it's our hope that at the end of the day, the updated ICRC commentary will provide more information than was available previously. This is just to provide an overview of what is not the topic of my substantive presentation, which are some of the main, sorry, I'm going too quickly, which are some of the main topics you will find dealt with in the First Geneva Convention. And this one is special because it includes all the common articles. So as you know, there are some articles which are common to all 4 Geneva Conventions. Common Article 1, obligation to respect and ensure respect. 2, definition of international armed conflict and occupation. 3, the all-important Common Article 3 on non-international armed conflict. Then there are provisions that are specific to the First Geneva Convention, and that really goes to the core, the ancient core of IHL, which is the protection of wounded and sick members of the armed forces in land warfare. So provisions dealing with wounded and sick, as well as all the ancillary protections which have been granted to military medical personnel, military medical units and transports. You will also find the in this commentary that has been published a couple of months ago, common articles at the end of each convention, and all importantly there are the provisions dealing with reprisals, grave breaches, as well as implementation. Without further ado, I'll go into the actual core of this presentation, which is within the Geneva Convention, the 2 provisions which explicitly deal with the offer of services. And the purpose of the exercise obviously being to show you that the actual text of the convention is very short, but that it requires a lot of detailed analysis in order to get the full picture of what this means in both theory and practice. We'll start with non-international armed conflicts. Common Article 3 stipulates that an impartial humanitarian body, such as the ICRC, may offer its services to the parties to the conflict. So this is very short. It only says an impartial humanitarian body, such as the ICRC, so taking the ICRC as an example, but also nothing but an example, may offer its services to the parties to the conflict. Then shifting to the parallel provision for international armed conflicts, more detailed and already gives you more information, and this is the main text we'll be working with throughout the remainder of this seminar. Provisions of this convention constitute no obstacle to the humanitarian activities which the ICRC or any other impartial humanitarian organization may, and here it comes, subject to the consent of the party to the conflict concerned, undertake for the protection of, and then the 4 conventions are different. 1 and 2 is wounded and sick and shipwrecked, as well as medical personnel and chaplains. 3 speaks about humanitarian activities for the benefit of prisoners of war. And 4 is about civilian persons. And then in the end comes, it's not only for the protection, but also for their relief. So let's disentangle this text one aspect after another. Before I do so, just as a reminder, which is not the topic of the presentation today, is that these are obviously not the only provisions in IHL dealing with humanitarian activities. There's quite a bit of activities that have been explicitly, where the role of humanitarian agencies has been explicitly mentioned. Just one example is ICRC visits to prisoners of war, dealt with in the Third Convention, or the role of relief agencies when it comes to sending relief parcel to prisoners of war. There is also, obviously, of course, in the additional protocols, there's a number of articles dealing with humanitarian activities. And last but not least, also in customary law, a number of rules have been identified by the 2005 ICRC customary law study, which equally deal with the topic we're talking about today. But so here we will only be speaking about the Geneva Convention. So the starting point, obviously, if everything which I'm developing as of now, the assumption is that there is an armed conflict. So we're not dealing here with the legal framework applicable to humanitarian activities in peacetime, for example, in response to natural disaster. Everything which follows deals with humanitarian activities in wartime, time of armed conflict. Before we even get to where Common Article 3 and 9 start, which is the right of agents of humanitarian organizations to offer their services, it has to be recalled that as a matter of international law, humanitarian organizations don't have any responsibility as such to meet humanitarian needs triggered or created by an armed conflict. As a matter of international law, and it's important to continue to emphasize this, it's only the parties to the conflict which have the legal and primary responsibility to address those needs. Humanitarian agencies have been granted by both texts, which I just read out to you, a right, and this is an important notion, of course, it's a right for them to offer their services, which also means that an impartial humanitarian organization, when it decides to offer its services in the humanitarian field in order to alleviate suffering created by conflict, when it does offer its services, this may not be regarded upon as interference in the conflict or as an unfriendly act. States have explicitly recognized that, yes, armed conflicts generate significant humanitarian needs, and impartial humanitarian organizations have a right to offer their services. Now, this notion obviously deserves some clarification. Who is an impartial humanitarian organization? First comes the word, obviously, of organization, which presupposes something more than a loose assembly of two people who decide they want to carry out aid. The keywords obviously are impartial and humanitarian. Humanitarian being really in the sense of this is not political, this is not development, but these are organizations whose activities seek to alleviate humanitarian needs so that people can not only survive, but can live their life in dignity and with a certain amount of well-being. I'll immediately get into the activities this covers, but so the purpose obviously of the term humanitarian organization is to stick to humanitarian activities, not go into political, let alone military or intelligence gathering activities. And then comes this keyword of impartial. Now, impartial, for those of you who are familiar with the fundamental principles of the Red Cross and Red Crescent movement, you will know the difference between impartiality and neutrality, which the text nowhere requires. Impartiality has to do with the attitude an organization adopts when it comes to the victims. No discrimination in terms of distribution of relief, except on the basis of one criterion, which is needs and needs alone of the persons affected by the conflict alone. So impartiality is the way you approach your activities vis-a-vis victims. No discrimination, only prioritizing on the basis of need. Neutrality, which is not mentioned in the provisions, and so therefore also as a matter of law not required, is neutrality is the attitude one adopts vis-a-vis the parties to the conflict. Meaning we as an international in humanitarian organization have no stake in the armed conflict, and we don't care who wins or loses. We are agnostic as to the outcome of the conflict. The purpose is only to seek access in order to alleviate the suffering of the victims, the persons affected by the conflict. Now, obviously, in practice for a great number of organizations, neutrality will also help an attitude, and not only proclaimed attitude, but actual demonstrated practice of being neutral, will also help a great deal in order to gain acceptance and the consent that I'll speak about in a second. So before we go any further, because we'll now start talking about humanitarian activities, an important point in legal term that needs to be emphasized is that you may have, and you have in actual practice, actors other than impartial humanitarian organizations who deliver humanitarian activities. One example to cast it starkly is armed forces distributing food to civilians in an armed conflict setting. That the act of distributing food to persons affected by the conflict is obviously a humanitarian activity. But the key point in legal terms is that doing so does not transform the armed forces into becoming an impartial humanitarian organization. The importance of that argument also relates to the following, which is that the legal regime that I'll set out to you in the remaining 5 to 10 minutes before opening the floor for question only applies to offer of services formulated by impartial humanitarian organizations. So notably, the prohibition to arbitrarily refuse consent only applies when it comes to offers of services emitted by impartial humanitarian organizations. Now, let's focus for a moment on this important concept of humanitarian activities, which Common Article 9 uses. Humanitarian activities are divided into two separate threads, as the text of the convention itself indicates. One is protection, and the other is relief or assistance. Both terms can be understood to be interchangeable. Now, it's important to emphasize that when it comes to an offer of services, which may include both protection and assistance, both really need to be perceived as being flip sides of the same coins. In other words, they frequently have to be together in order to be effective. Because what is a regrettable tendency in certain contexts is that parties to an armed conflict are happy for humanitarian organizations to be doing the assistance part, the food, the water, the medicine, etc., yet much less comfortable to engage in protection activities, and let alone a protection dialogue. So what is exactly covered by both protection and relief? There's no definition provided in the treaties, and there's also not a list of activities of what are humanitarian activities. Now, in a way, this makes a lot of sense because it's frequently impossible to define in advance which specific humanitarian needs will be created because of an armed conflict. Things that are not a humanitarian need in the beginning of an armed conflict, say a short-lived armed conflict, may become one if the armed conflict extends into months, years, let alone decades. Humanitarian in this sense being understood as every activity that is there to not only allow people to survive, but also to allow them to live their life in dignity. And so activities that in a short-term armed conflict will not be humanitarian may become so in a longer term armed conflict because of the protected nature of the situation. Now, assistance relief, I think for everybody is easy to understand. This is all food, medicine, blankets, housing, etc. Everything in material terms people need to be able to survive in dignity. Protection is really one of those terms that it's used in the convention. It's not defined there, you will find in the commentary the ICRC understanding of protection. Protection is really one of those words which, as all of you will immediately know and agree with, which are used by various people for very different purposes. So people use it without necessarily meaning the same thing. For an impartial humanitarian organization such as the ICRC to use this term is that if a protection activity is an activity that seeks to ensure that the parties to the conflict, who they are the ones who have the legal obligation to implement IHL, to make sure that they implement the rules. So it's about making sure that the rules are implemented, or if violated, that that a stop is put to the violation, or that those who violated it are being prosecuted. Now, why did I say that protection and assistance are flip side of the same coins? It's what's the sense of having people assisted, so for example, fed, if only to find out that the next day they are being harmed or killed in an unlawful military activity which goes against violation of IHL. From the other side as well, what's the point of having people well treated correctly in terms of correct compliance with IHL, so they are protected, if they starve from hunger? So both really go together and cannot be separated. Now, who are the beneficiaries of humanitarian activities? And there, a point I'd like to underline is that when listening to certain media reports, one often gets the impression that humanitarian activities is actually only about assistance for civilians. Now, assistance for civilians, yes, of course, is a core humanitarian activity, but as I said, it's also protection. And in terms of beneficiaries, it's basically everybody affected by an armed conflict, victim of an IHL violation or not. What the conventions do for international armed conflict is explicitly single out the wounded, sick, and shipwrecked, so members of the armed forces, the military medical personnel, and the POWs. So important to underline, humanitarian activities may also be undertaken for the benefit of those who used to be combatants. And now we get to the end and also to the crux of the matter. All the texts that I've been dealing with so far indicate is that organizations have a right to offer services. That's where the texts stop. They don't tell you what the party to the conflict which receives this offer of service, how that party has to react. Is there any law on this issue? Now, interestingly, if you look at the initial commentaries from the 1950s, they say the attitude that the party to the conflict has to adopt is entirely discretionary. It may decide as it wishes, and it doesn't even need to provide reasons if it refuses the offer of services. Now, on this very point, the law has changed quite dramatically since the 1950s, in that since a number of years, a rule has emerged to the effect that an offer of services, if emitted by an impartial humanitarian organization, as I indicated before, that an offer of services may not be arbitrarily withheld. Now, there's 2 points that we need to look in separately. First is the element of the consent, which needs to be obtained, and secondly is the consent may not be arbitrarily withheld. First, whose consent? Common Article 3 doesn't say anything when it comes to non-international armed conflicts covered by that provision. Common Article 9 says that you need to seek and obtain the consent of the parties to the conflict concerned. Now, the interpretation provided in the commentary, for those who go on and read it, is that this is only the party in whose territory or under whose control the humanitarian activities are to take place. So if activities are taking place, say, in an international armed conflict, but only on the territory of one state, the other state doesn't need to give his consent or let alone be sought his views as to whether or not they agree with it. So concerned in the activity is only the party on whose territory or under whose control the activities will be taking place. Now, non-international armed conflict, and this is maybe something in the questions we can go in further, provides a different set of problems when it comes to consent, because one of the paradigmatic examples of a non-international armed conflict is a non-international armed conflict opposing a state versus an organized armed group. When it comes to activities undertaken on the part of the territory controlled by the state, obviously you only need consent by the state. But the question has arisen, not only in theory, but definitely in practice, to what extent, if you are going to implement humanitarian activities in the territory, the part of the territory controlled by the organized armed group, yes, you will need, in any event, that group's consent, but do you also need the consent of the sovereign, the state? And this has become particularly thorny in the, not the hypo, but real situation in a number of conflicts of the last few decades, where it is, in reality terms, possible to gain access to the part of the territory controlled by an organized armed group through the territory of a neighboring state. And what then is the legal situation in case this is possible and the group has given its consent, yet the government in charge and still in control, to the extent it exists, has said no. And this is obviously one of the key thorny issues that the commentary has had to deal with. Now, before wrapping up, so consent may not be arbitrarily withheld. There's no definition of what is arbitrary, but it is possible to delineate some contours. As I said before, the primary responsibility to meet humanitarian needs is with the parties to the conflict. So to the extent that these parties are themselves able and willing to impartially deliver themselves humanitarian activities, there's no reason why they would need to let in humanitarian agencies to do it for them. They have the responsibility, they do it, then they can lawfully say, no, we reject the offer of services. Other end of the spectrum is a party to the conflict which is either unable or unwilling to alleviate humanitarian needs. In that case, an offer of services formulated by an impartial humanitarian organization will have to be accepted, and refusing it in that case will be arbitrary and therefore in violation of the international legal obligations applicable to that party to the conflict. Now, in between, there are debates over various scenarios. One point I will highlight, though, is that arguments of military necessity, such as there are military operations going on, it's too dangerous and therefore we reject the offer of services. Arguments of military necessity may not be invoked at the level of the consent. They may be invoked, and this is the last step in the analysis, at the level of once an offer of services has been accepted. Of course, that doesn't mean that the impartial humanitarian organization has now received a blanket check to start walking around wherever it wants in the armed conflict zone. The state obviously retains a legitimate interest and right to impose measures of control, if only to make sure that what is claimed to be humanitarian is not actually a cover in order to supply weapons or other military goods to the enemy side. So the party to the conflict has the right to impose measures of verification and also to invoke the argument of military necessity so as to temporarily and on a geographically as limited as possible basis restrict the activities of the humanitarian organization. With that, I've exceeded by a couple of minutes the time that I'd agreed upon with PHAP for the initial part of the presentation, and I'll hand it over to Anne-Harriet, and more than happy to answer questions regarding both parts of the presentations. Thank you.
Excellent. Thank you very much, Bruno. And yes, a call out to all of you who may have questions in your mind. Please do type those in now to the Ask a Question box, and I'll be very happy to pose those to Bruno in the coming minutes. If you have questions that are not quite within the scope of today's presentation, but nonetheless related perhaps more broadly to the Commentaries project or some other aspects of the work, feel free to email those those to us or email them to Bruno, we can share contact details at the end, and he'll be happy to forward them to the right colleague or to respond outside of the context of today's session. But certainly encouraging as many questions as you have about the topic for today, so do send those in. So to start things off, and we've received a number of questions already, we have one, Bruno, that's come in from Ilya, who I think is based in Geneva, asking the following question. So if humanitarian organizations should comply with principles and be agnostic, as you said, regarding the outcome of a conflict, which is uncontroversial, how then do discussions over, quote, breaking silos between humanitarian, development, peace actors, etc., how can these affect or maybe even jeopardize humanitarian action? For instance, if a humanitarian organization works together with a peace-building organization, could that be grounds for a state to refuse consent to humanitarian assistance because that organization is, quote, political or not entirely humanitarian?
Thanks for that question, which partially evokes broader questions of humanitarian policy that are outside the scope of this presentation. But I think the core question, as I understand it, is if a humanitarian organization is collaborating, however defined, with a peace-building organization, is that, if I understand the question correctly, is that a legal ground in order to refuse consent? Now, obviously, there's various elements to this question of being an impartial humanitarian organization. One is to claim, to unilaterally claim to be one. The other element, critical and the proof of the pudding element in practice, is it's fine for you to claim it, but do we parties to the conflict believe you are not, despite what you may assert with your words? And in particular circumstances, indeed, I think that if a humanitarian agency is too closely involved with the political activities of, say, a peace-building organization,
Sorry, we've just temporarily lost Bruno, but we'll have him back in just a moment. My apologies.
Can you close the door? Hello?
Hi, Bruno. Yes,
yes.
We lost you just as you were saying if a humanitarian organization is involved too closely with political, and then we lost you. Apologies for that.
Yeah, no, so obviously it's impossible to provide the generic every one-size-fits-all answer, because everything will depend on the circumstances. But the truth will always be in the eye of the beholder, which is the party to the conflict confident and comfortable that a given organization not only claims to be impartial and humanitarian, but it also is and will continue to act as one. So in the example provided, it may, if there's too close a proximity between a humanitarian organization and a peace-building organization, then yes, a party to the conflict may decide that this particular organization does not qualify.
Okay, so we have a follow-up question, Bruno, and forgive me if we're straying too far from the strict scope, feel free to let me know and we can move to other questions. But a follow-up from David. So he asks, so to clarify, so for a humanitarian organization to remain, quote, impartial, does that mean that it can't refuse to render humanitarian assistance to, say, listed members of a terrorist group?
Can you repeat the exact question again?
Yes, so to remain, quote, impartial, a humanitarian organization may not refuse to render humanitarian assistance to known terrorist personnel.
Okay, this is obviously an excellent question because it evokes the debate about the interplay between the fact that as a matter of IHL, what are called parties to the conflict will refer to groups that are by other branches of domestic, by other branches of law and other agencies of a state. The same group which will be for IHL purposes a party to the conflict may be listed as a so quote-unquote designated terrorist organization for the purpose of criminal law. Now, there's various elements. One is the fact that as a matter of pure IHL, it remains an entitlement of an impartial humanitarian organization to offer its services to any party to the conflict. Whether or not other people call them terrorists or not, IHL doesn't care. Now, obviously, the reality is that some of these groups are, as I said, called terrorist organizations for different purposes. And so there is, since many, many years, a well-known clash between competing paradigms where certain states have taken steps that go as far as criminalizing the provision of humanitarian activities to these agencies. From the IHL perspective, this is if the question is do they must refuse, the answer is obviously no, because they are party to the conflict. There are persons affected by their activities, and so there is a right to offer services.
Okay, excellent. Thank you. So we have a question now, a question of clarification from Yannick, who is asking, regarding the definition of humanitarian assistance, does the customary obligation of parties to allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need, does that also include protection activities? And I know you touched on that in your presentation, but if you wouldn't mind elaborating a bit.
Can you just please explain the precise question?
Yes, so regarding the definition of humanitarian assistance, Yannick is wondering if the obligation of parties to allow and facilitate rapid and unimpeded passage of humanitarian relief, does it also include protection activities?
As a matter of text and as a matter of both the customary law rule as well as the AP1 rule, obviously not. But I think the argument, as I hinted upon in my presentation, should be that you cannot disassociate assistance from protection. And so therefore, to the extent that they obviously what they have in mind with this rule, which I didn't touch upon in my presentation, the rule of states which are not party to the conflict, but to allow and facilitate the so-called rapid and unimpeded passage of relief consignments, what they had in mind is physical goods that need to be transported, and therefore as expeditiously as possible transported throughout the given territory. But I think that the argument may very well be made, constructively speaking, that to the extent that there is a need to rely upon the assistance of other states or of the enemy, that should equally be covered.
Okay, excellent, thanks. So moving then to a bit of a different tack and looking a bit more at the process. So I guess the first part of your presentation, Bruno, we have a question from Darren in Canada asking, to what degree was input sought from other concerned organizations? And he mentions in particular national militaries and regional organizations, for example, NATO, the African Union, etc.
Okay, that's an excellent question. I think that there's various there's various steps in our process that we need to separate. First is the research phase, because obviously we don't start writing commentaries just making up what we write. We first do for every single provision quite a substantial amount of research. And within the context of research, quite a number of questions came up in terms of how does this actually still work in practice. And so sitting here in Geneva obviously doesn't help to get an answer to all of these questions, but fortunately the ICRC has a lot of colleagues around the world that were able to help. And as part of that process and as part of the confidential engagement between the ICRC and certain both militaries and regional security organizations, there have been interactions in order to gain certain pieces of information as to how do you actually do this in practice. Now, input, so that was at the research phase. From there on, it's important to emphasize that, so the ICRC commentary, it's not a binding product, and it's also not a product for which we have sought nor will seek any form of official endorsement by states. So as I said, a lot of people were involved, and you will find all the details on our website, but everybody did so, from those who were consulted, including the peer reviewers, they all did so in their private capacity. Now, within the limits of that framework, there has been a number of both serving members of the armed forces as well as of the UN, from the UN side, who have been involved as peer reviewers to review it. But formally speaking, the text is not submitted to anybody for approval.
Okay, excellent. Thank you. So we have another question that came in from Bob, based in the UK, and I'll read it out. This one's a little bit lengthy, Bruno, but yeah, let me know if you need me to repeat any part. So, in a situation of the restriction of humanitarian access to the population of an area where the controlling power claims to be restricting access on the basis of security, is there a secondary obligation upon the power in control of that area to provide support with a longer view to the needs of a community once the security concerns are no longer present? And that's acknowledging that security concerns should not overrule humanitarian imperatives, but in many cases in practice they do for a period of time.
Okay, if I understand the question correctly, so restricting access based upon alleged security reasons, and how it then develops from there onwards.
Yes.
So as I said before, so the assumption is already we have had an offer of services by an impartial humanitarian organization, and that offer has been accepted at the generic level. But then when it comes to the actual implementation of tomorrow, we want to go to that province in order to carry out this activity, the party says, no, sorry, you cannot do this because security reasons, there's an ongoing or imminent military operation. As I said, that invoking that measure of control or restriction is fully lawful within certain limits, the details of which you'll find in the commentary. Now, obviously, from the moment those security reasons have disappeared, the state can no longer lawfully invoke those reasons. So what is important to emphasize is that a state may not first say at the generic level, yes, please, by all means, we accept your offer of services, and then subsequently impose so many measures of control or so many formalities that in actual practice, they've negated their consent. So yes, military necessity may be invoked, but it needs to be temporarily and geographically limited. And from the moment the security reasons have disappeared, the obligation of the party to the conflict is, provided the other requirements have been met of the law as I presented to you, from that moment on, the party to the conflict has the obligation to allow the humanitarian activities to resume.
Okay, thank you. So it looks like we have one more question. This one is coming in from Angela, and making reference to the significant debate that was playing out a couple of years ago. It really came to a head around cross-border humanitarian assistance to Syria, and there was, as you recall, the open letter to the UN on humanitarian access to Syria, in which a group of legal experts were making the case that the UN already had the legal authority that it needed to act without the consent of Syria, and for example, making the point that in areas where opposition groups were in control, it was their consent required, not necessarily the consent of the state. And wondering, Bruno, did that debate, or were you and your colleagues looking at that debate in the context of working on the commentaries project? And in the end, do the commentaries now reflect perhaps both sides of that active debate, or did they come down on one side or the other?
It's an excellent question, because it deals with one of the big both practical and legal debates of the last few years. So just in terms of concepts, the notion of cross-border has been evoked. Just to distinguish it from cross-border activities are different from cross-line activities. So cross-line is, say, within the context of a non-international armed conflict, from government-controlled territory, you get access to the part of the territory controlled by the organized armed group. That is cross-line. Cross-border is different, is that you are going to cross an internationally recognized border, and the working paradigm in a number of conflicts has been from the territory of a neighboring state or through the sea. Now, cross-border as such is not a legal term. It doesn't appear in any IHL treaty or officially recognized text of normative value. It's a descriptive term that describes exactly this phenomenon. Now, cross-border, if there's nothing problematic if in order to do the cross-border, prior to doing the cross-border activity, you have gained the consent of all parties to the conflict concerned, including the government. Then from the legal side, all boxes have been ticked, basically. But for practical reasons, you decide it's much easier to do it straight away from a neighboring country into the part of the territory controlled by the organized armed group. Where the legal debates arise is the hypo that you are able to do this, but the government whose consent has been sought has said no, or has made it very clear, you are violating my sovereign my sovereign right to regulate who gets access to our territory. There's various elements to this complex debate. One is that Common Article 3 is entirely silent on this entire debate. It doesn't even evoke the notion of consent, although it's obviously understood that there has to be consent. Now, Article 3 on this critical point is different from, and it's impossible to ignore that it's different from Article 18, paragraph 2 of the second additional protocol, which also deals with relief activities for civilians in non-international armed conflicts covered by the second protocol, because Article 18 of the second protocol explicitly talks about the requirement to obtain the consent of the high contracting party concerned. Now, high contracting party can obviously only be the state, the government side. Now, despite the silence of Common Article 3, it's clear, so when looking first at the level of general public international law, it's clear from the logic underpinning general international law that in principle, any impartial humanitarian organization will only be able to carry out proposed humanitarian activities if it has consent to do so, because of the fact that any state has the sovereign right to regulate access, who gets access into its territory. So we're speaking about on the domestic law, did you gain lawfully access, physical access to that territory or not? Now, there have been situations in which exceptionally the seeking and obtaining the consent of the party to the conflict concerned was problematic. For example, when there have been instances of uncertainty with regard to which government is in control, or when the state authorities have collapsed or ceased to function altogether. In these instances, obviously, if there's no clarity who's still in charge, then maybe there's a less compelling need to continue to seek the consent, because no consent can actually be given by a functioning authorities. And then the really hard nuts, and there I will refer to the commentary article, paragraph 831 for those who are interested, which says that in addition, there may be cases where the humanitarian needs are particularly important. Whenever such needs remain unaddressed, the humanitarian imperative would require that humanitarian activities be undertaken by impartial humanitarian organizations such as the ICRC. So that is, at this point in time, what the commentary states on that very thorny issue, where you have competing considerations of sovereignty and sovereign control over territory versus humanitarian needs that may otherwise go unaddressed. Now, one final point before handing it over back to you: never forget in this entire debate that we have this notion of arbitrariness and the prohibition to arbitrarily withhold consent. So a government which decides to say no, you don't get access to the part of the territory controlled by the organized armed group just for the sake of it, or because they think that by doing so they may gain a military advantage, that is an obvious example of an arbitrary and therefore unlawful refusal of consent. Over to you, Anne-Harriet.
Okay, great. Thanks a lot, Bruno. As you were speaking in the middle of your response, we had another question come in from Adriana regarding the humanitarian imperative, and I think you addressed it very well, actually, as you wrapped up your comment. But thank you, Adriana, for your excellent question as well. So with this, I think I'll simply thank you, Bruno, for the really helpful presentation, very well structured. I think we're coming close to the end of our time. I'm just doing a final schedule. I have one follow-up question, if I may, Bruno, from David.
Sure.
So it's just whether the term humanitarian imperative appears actually in the Geneva Conventions themselves or just in the commentary.
No, only in the commentary.
Okay. Okay, great. Thank you for that. So yes, we've come to the end of our time. If any of you who are participating today have follow-up questions, feel free to send us a message. My colleague Marcus will put our contact details in the chat, and we can forward that on to Bruno. Or Bruno, if you want to put your contact details, you're very welcome to do that. As Marcus mentioned in the chat, a recording will be available, so you'll be able to listen to the recording and also see in that context the presentation. And last but not least, I wanted to point out that we have a second online expert briefing coming up in just a couple of weeks, also in collaboration with the ICRC in the context of the work on the commentaries. And the subject for this next session, which will take place on the 30th of June at the same time, is care for the wounded and sick, looking at legal obligations in today's armed conflicts, and that will be with Bruno's colleague Lindsay Cameron, also legal advisor with the ICRC, who will be joining us on the 30th. So thanks once again, Bruno, and thank you very much to all of you who joined us today, and we look forward to seeing you next time. And Gerard Lang signing off from Geneva.